All right, so the sales contract did have some changes to it as well, some in light of these recent lawsuits and settlements, and some other ones that are in light of changes in Virginia law. The first section, which we've been talking about a couple times already, is the change to the first page, where you're going to see a new line item that specifies the amount that the seller will pay the buyer's broker, expressed as either a percent or a dollar amount. We just mentioned that there are certain third-party beneficiary rights of the buyer's agents and listing agents that are also now written into the contract. So it's just an additional paragraph on that sales contract that you'll see now, but make sure that it is in compliance with what you have agreed to with the parties, and make sure that's in compliance with your brokerage agreement as well, to the extent that is applicable. The other section that you're going to start seeing some changes on is that paragraphs 3 and 27 were changed to clarify that you're going to be using business days and not calendar days when calculating certain time periods. And for folks like me that work in Virginia, DC, and Maryland, it's always a hard time keeping track of what's calendar days, what's business days, when do I start counting, what time of the day was this ratified, things like that. Quick little cheat sheet for the NVAR contracts. Business days are always going to be used now for your earnest money deposits and for calculating when settlement is. For earnest money deposits, obviously banks are closed on weekends, so that's more of a practical change they implemented to say, okay, if you ratify on a Saturday and you have the 1 day to deliver an earnest money deposit, there doesn't need to be a rush or concern about calling a closed title company to get wire instructions or delivery instructions. That will all take place the next business day on a Monday. Keep in mind, federal holidays always impact that as well. The second is for settlement. This is also now going to always be on days that are not weekends or federal holidays. So just important to keep those in mind. For everything else, for your financing contingencies, your notice is in relation to those contingencies, the time you have until to contact your settlement agent with that ratified contract, HOA condo review periods, which we're going to get into in a moment as well, and inspections are all calendar days. So it's only 2 changes that are business days here, but always important to keep that on top of your mind.
Well, and I think that's a great change too, because again, you've had a lot of times where you get these, in-state 4-day weekends that people aren't aware of, and then you've got 3 to 5 days that you're trying to get, whether it's your earnest money deposit or something. And of course, banks may be closed. I know we just had the July 4th holiday, which July 4th was on a Thursday. Then Friday, I know some banks were open, some were closed, some courthouses were open, some were closed. So that does add another little level of uncertainty, unfortunately, into the process.
Right, and if you're an agent also, no one likes getting the calls of saying, I haven't heard from the title company, saying I haven't gotten my earnest money instructions, and it's a Saturday, and now you can say, it's okay, relax, it's going to be on Monday, we're going to get it to you.
Delivered to my house because of that. So yeah, this makes it much smoother and easier on me. The other thing I wanted to point out was paragraph 4. When something doesn't fall on the business day, it's the prior business day. For years and years and years, it was after. And so again, it's like, oh, this is on Saturday, I'll just see you on Monday. And it's like, no, I think you better see me on Friday. Yeah, so.
Always important, even the small details matter in the contract, so always important to make sure you're aware of when settlement will be and when the important deadlines of the contract are, to ensure that both you and your clients are always protected adequately. Right? The next major change that I'm going to talk about is, honestly, even in light of all the changes from the settlements relating to these commissions, what I think is a huge departure in the contracts, and that is the changes to the periods in which you have to review resale documentation. So if you recall, a couple of versions of the contract ago, there was a change in Virginia law regarding the delivery of resale documents and how long folks had to review those. When that law was originally enacted, there was some question as to whether the legislature had inadvertently removed the mandatory 3-day protection. For months, I always thought that they were going to close that loophole, but turns out people may have enjoyed it, and now it is codified into Virginia law, and you see it in your contracts now, which is the time periods you have to review condo or homeowners association documents is entirely negotiable now. The 3-day mandatory period is gone. The first question I will ask both of you is, what's your take on this? Do you think it's a good idea to offer folks less time to review these documents?
You know, I mean, I always thought 3 days was certainly reasonable. I know what I've had happen over the past month, or a couple of months actually. We've had buyers and sellers agreeing that they would not, that the seller would not provide, and the buyer was okay not receiving the resale disclosure documents. Now, the problem with that is that because that's so baked in with the way that the associations operate, if a disclosure packet is not ordered, it's our experience that the associations then will not provide us any of the financial update, any fees or anything. Right. So we're kind of stuck. So when that has happened, we've had to prepare and have the parties sign a separate document saying, look, we don't know whether there's any special assessments. We don't know whether they are in arrears in their association dues. We don't know if there's been a change or even really what the association dues are. Right. So you all are essentially on your own. You understand. One, I hope that legislatively they will tell the associations that regardless of whether it's a disclosure packet, they need to provide that information. It's they really shouldn't hold it hostage to that. But that's just the practicality of where we are with these if you don't receive it.
Absolutely. So a couple of things that I'll mention is, one, this change does not obviate the need for the seller to deliver the resale package, or at least a notice that one does not exist. So that requirement is still in the law, in the contract. They still have to deliver it. What's changed now is your ability to negotiate the time in which the buyers have to review those documents. So in situations where folks say, well, lots of times we're getting questions now, it's folks asking, can we lower it to 0, 1, or 2 days versus the standard 3? You could always lower it. If you do lower it, I would recommend getting the notice of adverse consequences signed by that buyer to protect yourself as the agent. One thing I will also notice is that it's negotiable now. Just because it's not 3 doesn't mean it can't be 5. Yeah. So if the market turns and buyers start getting more leeway in terms of reviewing some of the more complicated packages that we see from time to time, you can now actually write in 5 days, 6 days, giving them more time to fully parse through all those documents, budgets, meeting minutes, things of that nature.
But if I'm the seller taking the...
You may not want to agree to that. Right?
Exactly. Why do you have that many more days to void the contract? Because that's the whole, not the whole point, but that was one of the benefits of the HOA docs to the buyer is, hey, I've got that many days. I, being the simple person that I am, I would rather not negotiate something like that. You asked what our opinions were. You know, this is not the opinion of Community Title, but Robin Mathis. And that is, Robin Mathis is a simple person. I just want a number in there. I want to see it. I want to know what the rules are. I do not like the fact that it's one more thing.
If it's left blank, do you know what the default number of days is?
I do not, but I have to assume it's
3 days.
3. Yeah, it goes back to where we were. Yeah.
But I think there's a trap in there though too, because again, the whole point of that statute was to make sure that the seller provided those disclosures to the buyer. The buyer had ample time to review it, and if they wanted to get out, they would get out. So they wanted them to have it out of the contract. Now we've added an element in there of negotiability. And so I think that the danger is some people hear, oh, the disclosure packet is negotiable. It's not, because if the buyer does not receive it, the buyer can get out of the contract, pretty much no questions asked. So up until settlement. So they could be there just waiting in the reception area to come in and decide, I just don't like the look on their faces. I don't want to go. And there's not a damn thing that anybody can do about it. And I don't know why any seller would want to put themselves in that position. But so I'm not really, this is a solution that was searching for a problem. I don't know why they did it. I think that, again, my concern is that when agents hear this and they hear that there's a portion of this that's negotiable, that they think that all of that is, and that somehow, so again, make sure, just emphasize that if they don't get it, buyers can still get out of that contract.
On the flip side of that, one question that I've been receiving recently has been for agents that know of the importance of delivering it, and while the contract is being worked on, hasn't been ratified yet, they say, oh, here's all the documents, by the way, for once we're ratified. Folks are wondering, when do you start counting days from that period? Is it when it's delivery before ratification, or is it ratification? And if you look at the contract itself, that 3-day period or whatever period you now negotiate to starts at ratification and not prior to.
Right.
And the other thing about that is delivery. But I laid it on the kitchen table of the house. Unless it says laying it on the kitchen table at the house is delivery under your contract, it's not.
They did make a change, though, that delivery now can explicitly be made to a buyer's agent or the either agent now, which is a change from the prior versions of the contract as well. And then the final thing that I'm going to talk about is off of the conversation that Robin, I know you and I have been having, which is there any authorizations in the contract itself for the brokerages to provide us as the title company copies of those agreements? These are not new changes to the contracts, but if you look at sections 4 and 22, the settlement agent does have responsibility to collect all commissions. They're authorized to collect the commissions and pay them on behalf of the seller or the buyer to the brokers. So we need to collect documentation in order to adhere to our obligations as settlement agent to the contract. Other than that, as we kind of mentioned, a lot of these changes were not necessarily so substantive. A lot of them are more stylistic and are going to impact maybe more of your day-to-day practice, but within the contracts, we hope you'll find that this is easily digestible and that, as we said a couple of times, everything will be okay. So thank you very much for joining us.
Thank you.